And I think the absolute most important thing you can do as a lawyer to facilitate getting a fair number for your client is to speak from your heart with integrity and mean it.
TBI cases can feel like navigating uncharted territory. Your client's injury is real, but proving it, that's where the real challenge begins. If you've ever felt like you're missing crucial pieces of the puzzle, you're in the right place. Welcome to Winning the TBI Case, where Tom Crosley shares the insights he's gained from over 60 injury trials. Not just the victories, but the lessons learned along the way that make all the difference. This is practical wisdom from someone who's been in your shoes and found a path forward. Winning the TBI Case. Strategy, science, and storytelling. In our previous episode, renowned trial lawyer Keith Mitnik shared why attorneys handling TBI cases need to know the science and have courtroom skills. Today, we're concluding our interview series with Keith with a deep dive into the specific challenges of jury selection and assessing damages when it comes to TBI cases. Let's rejoin the conversation.
So, a lot of times in a mild TBI case, there's not much in the way of medical expense. So we don't really get to use that old damage model of 3x, 10x. In fact, sometimes it's just underwhelming what the medical expenses are. So let me ask you this question. In a mild TBI case where you don't have a lot of medical expense, how do you set it up to be able to ask the jury for 8 figures?
In a case like that where they're not much, I don't bring them. And people worry about it. And I don't. And I'll tell you why I don't. A couple of reasons. And this isn't just mild TBI. It's any case where my medical bills dwarf in comparison to what I plan to ask for. And it's this simple. Sometimes insider information gets in our way. We know we like to present medical bills. We know not presenting them may be a little unusual. Guess who doesn't? The jury. You don't present the medical bills. We all think they're going to be going, something's missing. Why would they think that? If they're not presented, they got plenty to worry about. Number one. Number two, if it comes up, I've got an answer that is absolutely truthful and makes the other side wish they didn't bring it up, which is, I wish this was a case where there was $1 million worth of future medical care that would cure her. But there isn't anything they can do for this. And so we're not presenting medical bills because sadly, there's nothing medicine can do for it. She's going to live with it forever.
I like that. That works. How often do you find yourself in any type of case just not even presenting the medical bills?
Often. If I got a big medical bill, I love it. Because, I tell jurors it's whatever the cost to it, let's say it's $1 million in medical, past and future. Whatever it costs for doctors to come in and do a little bit, make it a little bit better for a little while, because there's no cure. Little better for a little while. And they're in and out of their life like this. That's medicine. It's not criticism. That's just the way it works. So if the value of someone coming in and out of their life quickly to do a little bit for a little while is $1 million, that pales in comparison to what it is to live with it around the clock. That's why that information is helpful as a baseline. But you've got to apply a substantial multiplier or it's ridiculous. And that's why we talk about 10 to 20 times that. And if you take 10 to 20 times that, that's $10 to $20 million. Now that's a lot of money, but that's a lot of hurt for a lot of time. And the doctor's bills tell you so. But I'm not going to do that if I got 50 grand in medical bills.
Right.
And it's not because, that trick doesn't work. That's not a trick. That's righteous. And it's righteous to drop the bills because the bills aren't reflective. It's just an apples and oranges situation.
Do you ever get scared that you're asking for too much money that in doing so would alienate a jury? How do you deal with that?
But does that mean I can just say, you know what? I'm going to do $1 trillion this time. I mean, you got to use your heart, your sense, your integrity. in the decisions you make. I use damage models, and my damage models lead me to where my boundaries are, but I don't have preset boundaries that I'm going to upset a jury. And here's why. I had a lawyer the other day. I wanted to ask for $12 million, and they really wanted me to keep it under 10. They wanted me to ask for 9. And I said, all right, I want you to think about this. I said, my math's taking me to 12. I can artificially lower it to make you happy. It's your case. I will. But I said, let me ask you this. Think about the jurors, picture them in your head, go down the line, look at every one of them. So, yeah, you're not feeling real good, are you? No. I said, I'm going to stand up and say $12 million, and you're afraid they're going to go, you son of a bitch. That's right. I said, okay, now start over. Picture them again. Now I stand up and say $9 million. So they're going to say, what a reasonable guy. I'm going to say, you're a son of a bitch anyhow. I said, I'd rather the conversation about the son of a bitch start at 12 than 9 because the first thing out of their mouth is going to be to cut it in half. I'd rather start at half a 12 than half a 9. And he goes, okay, ask for 12. And guess what?
What?
We got 8.
Oh, nice. Because you know they're going to cut you, right?
And you know what? They should have given us 12. I didn't ask for 12 so they would give me 8. I asked for 12 so they give me 12. But if I'm going to get screwed, I'd rather get screwed less.
Right.
So no, I don't worry about it to a degree. I'm not blind to it. And if I got a high-low, and I know the most I'm going to get is X on a high-low, it may affect what I do. But I'm not going to say, well, just ask for the high, because I know I'm never going to get the high.
Right.
You know, I know somebody who came up with an idea. Tell the jury in jury selection. Some lawyers ask for more than they want, and I'm happy to do that. Or I can just tell you what I want. You tell me what you want me to do.
You've done this?
No, I've heard of it. And I've heard people who really liked it. And you know what I thought? The jury's going to think before I ever get started, I'm full of crap.
Right.
Because they're not going to believe me. Have you ever gone to mediation where you told them, first number out of your mouth, this is really all I'll take, and settle a case? No one will believe you.
Right.
And I think jurors are wired to think you're asking for more than you want. So you better not ask for less than you want. But I tell you what I don't believe in. I always hear the anchoring. And I understand the psychology of it. I don't like the concept at all because there's a phoniness to it. And I think the absolute most important thing you can do as a lawyer to facilitate getting a fair number for your client is to speak from your heart with integrity and mean it. And if I got to anchor up to get here, then I'm talking nonsense. And I don't feel good, and I'm afraid they're going to smell it on me.
Right.
So if I don't feel good about my ask, I don't ask it. But if I do, I ask it and I mean it. It's not a ploy to go up to get more in the end. It works out that way.
Right.
But not because that's why I'm doing it. I realize they're going to probably cut it down. So I'm not going to cut it down artificially because I'm chicken to ask for what I mean. And I'm not going to ask for more than what I mean to try and get there. I'm just going to ask for what I mean.
I like that. I like the way you put it, that the most convincing way you can ask is to do it from your heart and mean it 100%, right?
And one thing you and I have learned, you and I are both old enough to remember when asking for $1 million on, let's say, a herniated disc case, people would have thought you lost your mind. And so you didn't do it. And you know what it was? We had been brainwashed that these cases that are worth $1 million were all worth $200,000. And we'd get $200,000 and get drunk for a week and think we're the greatest lawyer on the planet. Now I get $200,000 on that case. I'm like, God, what did I do wrong? And nothing's changed. It's the same injury. We just realized we were all fooled into lowball numbers we were taught by people who taught us, who were taught by insurance adjusters. No more. Them days are over.
I have a funny story to share about a very early case I tried. I was probably 29 years old when I tried this case. And the defense is allowed to send they call it a special exception, but it's where they can make you declare the maximum amount of money that you intend to seek in a lawsuit. You got to put it in your pleading. I'm like, goodness, I'm going to come up with an amount that's really, really high because I can never collect more than that amount under the law. And I'm also going to make it a unique number that makes it sound like it's real. So I came up with $1,825,000. I put that in there.
That was your unreal number.
Yes. Yes. It was not a brain injury case. It was a physical injury case. But in any event, that was the number. I think the pretrial offer was $150,000. And the defense lawyer gets up in jury selection after I've already done my part and says, they're suing for $1,825,000. And I was just, my face turned red. I was looking down at the floor. I was embarrassed.
Sure.
Because, I mean, gosh. Okay.
You didn't think anyone was ever going to hear it.
So fast forward to the end of the case. Try the case. I get a verdict of $700 and something thousand, which came out to, back in the prejudgment interest days, came out to $1 million. Anyway, I get this verdict, and one guy, the foreman of the jury, comes over to me after and says, I'm sorry. I know you wanted $1,825,000, and I tried to get it for you, but these people were just too stingy.
There's a lesson in there.
And I learned from that. If you want it, you got to tell them in the very beginning, right?
Yep. Listen, I try them in states where they do that. You have to do an interrogatory and give them the number. In the defense, I did it once and didn't know. I walked up and no one told me it was in an interrogatory. And the defense lawyer gets up and say, they're asking for so-and-so. And I leaned over to the lawyer and said, how the hell did they know that? And he told me. I said, well, it'd been nice if you'd have told me that that was out there and they were going to do that. So I went to the same state, tried one about a year later, and I got up and said, listen, we've made an official statement in this case of which we can't go over, and it is X. I said, probably not enough, but please, in this case, I'm not going to ask you to go one dime over it because it's a waste. We can't collect any of it. But for goodness sake, don't do any less. And I just did that in jury selection. The other guy, when he got up to say, ask him for it, I'm like, go on, have at it. But it's after I learned. I didn't know they were going to read it to the damn jury. I had the same thing.
Yeah.
I'm like, I wasn't embarrassed then because this was past my rebirth where I realized what the numbers really were. I just didn't know they were going to blurt the damn thing out.
Yeah. Well, that's great stuff, Keith, on how to ask for money and the mindset that we need to have, how to ask for money. And so thank you for sharing that with us.
If you're finding value in today's episode, here's how you can take your TBI practice to the next level. Subscribe to our newsletter at crosleylaw.com/podcast for exclusive case studies, resources, and trial strategies you won't hear anywhere else. That's crosleylaw.com/podcast, or click the link in the show notes below. Don't just listen to the strategies, implement them.
Keith, do you think the trial of a severe TBI case is different than a mild TBI case in terms of how you present it and what becomes important in the case, in the damages side?
I haven't tried two of them close enough together to have gone through that thought process. They feel different. Tell me your thoughts.
Yeah, so I think there's two huge differences from my standpoint. One is the fight, like you mentioned earlier, it might be more over liability if you're trying the severe TBI case, but often the fight is also on the damage model because these damage models will run into the tens of millions of dollars.
Yeah.
Yes. The economic damage. So it'll be a life expectancy fight, or this injury is so severe that they're not going to live the 40 years that you say they're going to live, or they're not going to need
you don't need all this stuff,
the in-home health care and the aids and all those things that add up to lots of dollars over time. So in my mind, the big battleground on a severe TBI case is drawn around that big economic damage life care plan.
Yep.
What do you do differently when you're trying that type of case? What do you think becomes the most important thing you can do to bolster that part of the case?
Well, one of them is not so much a getting the case ready for it, is tearing their experts down in opening statement, because they're going to come in last and they're going to get the last word. And they never hire someone that doesn't have good credentials and a lot of experience and isn't a good talker. And you're not going to take them down by all the money they made, because your people have testified and they got paid a bunch in those kind of cases too. So money isn't going to carry the day. It's got to be something they're saying. They almost always, my experience is those experts will say 5 things that are really a reasonable position. It's not that they're right, but it's not unreasonable. It's really like two positions where people just aren't agreeing on what's best. They almost always have one or two where they can't help themselves and they cheapskate out and look unreasonable. You got to use that in opening to destroy their credibility. You don't need to destroy them on everything.
How do you do that?
In opening, I put up a slide, show their face, and I have a couple bullet points on the slide about who they are and all. I usually do not put what I'm taking them down on in case we have to exchange slides. Right. And then I get up and say, now let me tell you, this guy's been hired by them and paid a lot of money by them, handpicked by them. He's worked with them a bunch. However, in fairness, we paid our people a lot of money and worked with them too. So you ought to consider it, but consider it even handily. I don't want to be a hypocrite here. I said, but let me tell you what I want you to focus on. Because when he comes in and testifies, I'm going to cross-examine him, and I'm going to point this out. And I know what the evidence is going to show on it because he's already said it under oath. So let me tell you what he's going to say. Boom. And then I drop the bomb on him. That's what he's going to say. And that's the guy they're asking you to believe. Yeah. There's an old adage. Right. If someone ain't shooting straight on one thing, how are you supposed to figure out if they're shooting straight on anything?
So that applies across the board to any defense
expert. I believe my best cross-examination happens in opening statement. And the reason is, if you wait, they put them on. They climb up on a pedestal. And the jurors eating out of their hands. Occasionally they hire a jackass, but usually not. They bring someone and the jurors want, I love this guy. I wish he'd treat my family. I want to have coffee with him. Now you got to try to bring them down.
Right.
And usually you don't have that much to bring them down with. I don't let him get up on the pedestal. I'll say in opening, and I'll tell you how you know he's going to get here. He's got a bit of an unusual name. It's Dr. Fitz. And Dr. Fitz, he wears this beautiful suit. He's going to come in and he's nice suits. I've crossed him a lot. And he's got this gorgeous silver hair. I wish I had it. And you'll know he's here. They're going to say, call your next witness. And one of these gentlemen or ladies is going to stand up and say, we call Dr. Fitz. When the guy walks in that beautiful suit and that white coif hair, that's the guy I'm talking about. And now he walks in. He sits down and he's expecting the jury to fawn on him. And they're all like, and he's thinking, what's my fly down? What happened? No, buddy, I beat your ass before you ever walked in the courtroom. Now I don't have to take you down very far.
Nice. Well, Keith, thank you for sharing your wisdom with us today. I really appreciate it. If any of our listeners wants to get in touch with you, what's the best way for them to do that?
Sure. The letter K, Mitnik, M-I-T-N-I-K, not C-K. I won't get it. Anyhow, M-I-T-N-I-K @forthepeople.com. And if you write me, I do it was at home but not alone brushstrokes I sent out often, 12, 15, 20 times a year. It's so far since COVID, I changed the name to Handpick Hot Tips by Mitnik. If you send them to me, I will catch you up on the old ones and send them to you. They don't cost anything. It's just something I do as a give it back thing because I've had a lot of people give to me and I'm fortunate and I like to give. And if I got a good idea, I like to share it with you.
You've got a lot of pearls of wisdom to share, my man. So thank you very much for doing that. Okay. And I appreciate you.
Thank you for having me.
If today's episode helped you see your current case in a new light, share it with a colleague who's facing the same challenges in a case. Subscribe wherever you get your podcasts and join our community of trial lawyers who refuse to settle for average results. This has been Winning the TBI Case. Strategy, science, and storytelling with Tom Crosley.